authority to extend legal protection to non-forest habitats such as grassland. The right for protection, improvement of the environment assembly legislation that constituted the Provision Water Act 1974, Air Act 1981, prevention and control, coordination of action by the state government officers and other planning, execution, nationwide program for prevention, control, and abatement of environmental pollution, linked on procedures safeguard for the prevention of accident because of environmental pollution, remedial measure for such accident, linked on procedure and safeguard for handling hazardous inspection of any premises. Objective to extend legal protection to non-forest provides for protection, improvement of environment, Water Act 1974, Air Act 19, coordination of action by the state government of its nationwide program for prevention, control, and abatement, laying down procedures safeguard for accidents as a premises. Umbrella legislation consolidates Water Act 1974, Air Act 19, coordination action by the state government of its authorities, planning, execution, nationwide program for pollution control, agent procedure and safeguard for accident and hazardous inspection, power to check premises, plants, material, substance, can issue direction to authorities or person for taking necessary steps. 1919 is a Bhopal gas strategy based on Article 253 of the Indian Constitution, Section 26, about legal framework for environmental protection. Passed take nature applies to all of important authorities and the power to take measure, issue direction, make rules, state coordination of action, implementation of program officers and carry out function, inspection and enforcement. Environment Protection Act 1986, collection and dissemination of information relating to environmental pollution, coordination of activities already created, regulating the preparation of manuals, codes, and or guides related to prevention, control, and abatement of environmental pollution. Objective: creation of authority of environmental protection, regulation on environment pollution, hazardous substance, speedy response in event of accident, and punishment to guilty who threatens the environment. Constitutional provision, Article 48A, protection and improvement of environment, a safeguard, protection and improvement of environment and safeguarding of forests and wildlife. Article 41, protect and improve the natural environment. The Act under Section 1516 prescribes for a punishment up to 5 years in jail or with up to 5 lakh rupees and Environment Protection Act 19, collection and dissemination of information relating to Environment Protection Act. Environment Protection Act 19, collection and dissemination of information relating to environmental pollution, preparation of manuals, codes, guides in relation to prevention, control, abatement of environmental pollution, coordination of activities already created, regulating agencies, objective creation of authority of environment protection, regulation, environment pollutant, hazardous substance, speedy response in event of accident and punishment to guilty who threatens the environment, constitutional provision 48A, protection, improvement of environment, safeguarding of forest and wildlife, article 51A, protect, improve the natural environment, punishment. The act under section 15, 16, 17 prescribe for a punishment up to 5 years in jail or with a fine up to 1 lakh rupees or both. Loopholes: no independent regulatory body, penalties for contravention are too weak, lack of competent people and the lack of funds. Polluter pay principle. Environment litigation, more expensive solution, independent regulatory authority, polluter pay principle, reward mechanism, political will, public awareness, less political interference, stringent rules and regulations. Environment Protection Act 19, collecting and disseminating of information relating to environmental pollution, preparation, manuals, codes, or guides relating to prevention, control, abatement of environmental pollution, coordination of activities already created, regulating agency, objective, creation of authority of environment protection, regulation of environment pollutant, that is speedy response in event of accident, punishment to guilty with the Constitution, Article 48, protection, improvement of environment, safeguarding of forest and wildlife, Article 15, protect and improve the natural environment, punishment. The Act under Section 15, 16, 17, for punishment to 5 years with a fine up to 1 lakh rupees or both. Environment Protection Act 1986, collection and dissemination of information relating to environmental pollution, preparation of manuals, codes of guides relating to prevention, control, abatement of environmental pollution, coordination of activities already created, regulating agencies, objective creation of authority of environmental production, protection, regulation, and environment pollutants, hazardous substance, speedy response in the event of accident and punishment to guilty who threaten the environment, constitutional provision, Article 48, a protection and improvement of environment, and safeguarding of forest and wildlife, Article 51 AG, to protect and improve the natural environment. The Act under Section 15, 16 prescribe for a punishment up to 5 years in jail or with a fine up to 1 lakh rupees or more. Solution: independent regulatory polluter reward mechanism, political, less political intervention, stringent rules and Environment Protection Act 19, collection and dissemination of information relating to environmental pollution, preparation of manuals, codes, or guides relating to prevention, control, and abatement of environmental objective, creation of authority, environmental protection, regulation of environmental pollutant, hazardous substance, speedy response in event of accident. Article 48, a protection improvement of environment, a safeguarding of forest and wildlife, 51, a protect and improve the natural environment. The Act under Section 15, 16, 17, pray for a punishment up to 5 years in jail or with a fine up to 1 lakh rupees or more. Solution: independent regulator, polluter pay principle, reward mechanism, political will, political rules and regulation. Emergence of global industrial human culture has impacted environment so adversely with increasing force intensity that the already existing ecosystem may gradually be degraded to the extent that forms of life presently existing are no longer in a position to adapt to the changed condition. Therefore, the fear that haunts us today is that people may destroy the environment along with themselves unless something is urgently done. All's well Global industrial culture has severely impacted the environment. Ecosystem is degrading, and forms of life may not. So people may destroy the environment along with themselves. Urgent action is needed to protect environment and important environment protection law. Environment protection 19 maintain law for environment protection in India. Take away protect environment, save life, act environment, save life, act responsibly, act urgently, save environment, save life. Save environment, save life, act today for a better tomorrow. Emergence of global industrial human culture has impacted environment so adversely with increase in force intensity that the already existing ecosystem may gradually be degraded to the extent that forms of life presently existing are no longer in a position to adapt to the changed condition. Therefore, the fear that haunts us today is that people may destroy the environment along with themselves unless something is urgently done. What are the key points? Global industrial culture has severely impacted the environment. Ecosystem is degrading and forms of life may not survive. People may destroy the environment along with themselves. Urgent action is needed to protect environment and life. Environment Protection Act 1986 maintain laws for environmental protection in India. Take away protect environment, act responsibly, save life, act urgently. Save environment, save life, save environment, save life, act today. Save environment, save life, act today for a better tomorrow. Right to Information Act 2005. Background: Universal Declaration of Human Rights was adopted in 1948, providing everyone the right to seek, receive information and ideas. Genesis of RTI law started in 1986 through SC judgment in the case of Jaipur Municipal Corporation case. Objective to empower citizens, to promote transparency and accountability, to contain corruption, to enhance people's participation in democratic process. Reason for adoption: corruption and scandals, international pressure and activities, modernization and information society. Features of Act: Section 2 clause A, extend to whole of India. Section 2J, information means any material inform including record, documents, memos, emails, opinion, advices, circular orders, logbook, contracts, reports, data held in electronic form, and information relating to any private body which can be accessed by public authority under any law for the time being in force. Section 2H RTI means the right to information accessible under this Act, which is held by or under control of any public authority and includes right to inspection of work, take notes, extract certified copy of document, taking certified sample of material, obtaining information in the form of electronic record or printout, inspection of works, document record, taking notes, extract or certified copy of document, taking certified sample of material, obtaining information in the form of electronic record or printout. Right to Information Act 2005 background. Universal Declaration of Human Rights was adopted in 1948, providing everyone the right to seek, receive information and ideas. Genesis of RTI law started in 1986 through SC judgment in the case of Jaipur Municipal Corporation case. Objective to empower citizens to promote transparency and accountability, to contain corruption, to enhance people's participation in democratic process. Reason for adoption: corruption and scandals, international pressure and activists, modernization, information society. Features by Article 2. Information means any material in any form include records, documents, memos, circulars, logbook, contract report, data held in electronic forms, and information relating to any private body which can be accessed by public authority under any other law for the time being in force. Section 2H RTM means the right to information accessible under this Act, which is held by or under control of any public authority and includes right to inspection of work, documents, records, taking notes, extract a certified copy of document, taking certified sample of material, obtaining information in form of any electronic record or printout. Right to Information Act 2005 background. Universal Declaration of Human Right was adopted in 1948, providing everyone the right to seek, receive information and ideas. Genesis of RTI law was enacted in 1986 under the SC judgment in the case of Jaipur Municipal Corporation case. Objective to empower citizens, accountability, transparency, contain corruption, to enhance people's participation in democratic process. Reason for adoption: corruption and scandals, international pressure and activist modernization, and information society. Features of Act. Article Section 2J information means any material in any form including records, document, memos, emails, opinion, advices, circular order, logbook, contract report, data in electronic form, information relating to any private body which can be accessed by public authority under any other law for the time being in force. Section 2H RTM means the right of information accessible under this Act, which is held by or under control of any public authority, include right to inspection of work, taking notes, extract, taking certified sample of material, obtaining information in form of any electronic record. RTI Act 2005 Universal Declaration of Human Rights was adopted in 1948, providing everyone the right to seek, receive information and ideas. Genesis of RTI law was enacted in 1986 through SVG judgment in the case of Jaipur Municipal Corporation case. Objective to empower citizens to promote transparency and accountability, to contain corruption, to enhance people's participation in democratic process. Reason for adoption: corruption and scandals, international pressure, activists, modernization, information society. Section 2J information means any material in any form including. Section 2J information means any material in any form including rewards, document, memos, email, opinion, advices, circular order, logbook, contract report, data in electronic form, and information related to any private body which can be accessed by a public authority under any other law for the time being in force. Article 2H RTI means the right of information accessible under this Act which is held by or under control of any public authority and include right to inspection of work, taking notes, extract or certified copy of document, taking certified sample of material, obtaining information in an electronic record or printout. What is public authority? It means any authority or body or institution of self-government established or constituted by or under the constitution by any other law made by parliament or state legislature by notification issued or order made by the appropriate court. Section 4 suo motu disclosure of information by public authority. Section 8 clause 1 exemption against furnishing information against under RTI Act. Section 8 Clause 2 Disclosure of information exempted under Official Secret Act 1923 if larger public interest is served. RTI provision. The Act also provides for appointment of Information Commissioner. Time period in normal course within 30 days. Concerns life and liberty of person within 48 hours. Importance did not create any new bureaucracy for implementing law. Instead, it tasked and mandated officials in every office to change their attitude. Key to strengthening participatory democracy can empower the poor and weaker section of society, making government more accountable by subjecting it to public scrutiny, improve decision making by removing unnecessary secrecy. Key features of Act. RTI empowers citizens and promote transparency and accountability, enhance people's participation in democratic process. It strengthens democracy and create awareness. Information is power. Use RTI, strengthen democracy. Again, what is RTI Act 2005 and what is public authority? It means any authority or body or institution of self-government established or constituted by or under the constitution by any other law made by parliament or state legislature by notification issued or order made by the appropriate court. Section 4 suo motu disclosure of information by public authority. Section 8 clause 1 exemption against furnishing information under RTI Act. Section 8 clause 2 disclosure of information exempted under Official Secret Act 1923 if it served on a larger interest. RTI provision. This act also provides for appointment of Information Commissioner. Time period normal course within 30 days. Concern life and liberty of person within 48 hours. Important did not create any bureaucracy for implementing law. Instead, it tasked and mandated officials in every office to change their attitude. Key to strengthen participatory democracy can empower the poor and weaker section of society, make government more accountable, improve decision making by removing unnecessary secrecy. What is public authority? It means any authority or body or institution of self-government established or constituted under the constitution or by any other law made by parliament or state legislature by notification issued or order issued by appellate court. Section 4 suo motu disclosure of information by public authority. Section 8 clause 1 exemption against furnishing information under RTI Act. Section 8 clause 2 disclosure of information exempted under Official Secret Act 1923 if larger public interest is served. RTI provision. The Act also provides for appointment of Information Commissioner. Time period in normal course within 30 days. Concern life and liberty of person within 48 hours. Importance did not create any new bureaucracy for implementing law. Instead, it tasked and mandated officials in every office to change their attitude. Key to strengthening participatory democracy can empower the poor and weaker section of society, make government more accountable by subjecting it to public scrutiny, improve decision making by removing unnecessary secrecy. Key features of Act. Information means any material in any form, including record, document, memos, emails, opinion, advice, circular held in electronic forms, information related to any private body which can be accessed by a public authority under any other law for the time being in force. Section 2, Clause H. RTI means the right of information accessible under this Act, which is held by or under control of any public authority and includes right to inspection of work, taking notes, taking certified example of material, obtaining information in the form of electronic record or printout. Conclusion. RTI empowers citizens and promotes transparency and accountability. It enhances people's participation in democratic process. It strengthens democracy and create awareness. Information is power. Information is power. Use RTI. Strengthen democracy. What are the challenges? Misuse the law and harass the public authority, asking for desperate and voluminous information to obtain publicly by filing to obtain publicity by filing RTI, illiteracy and unawareness, absence of grievance redressal mechanism. Political parties under RTI do not contain corruption. Huge donation from corporates leads to wrong capitalism, illegal foreign corrupt contribution, use of money power to influence the voting election. Conclusion was made to achieve social justice, transparency, and to make accountable government. But this act has not achieved its full objective due to some impediments created due to systematic failure. RTI is necessary but not enough. A lot more is needed to be done to ensure accountability in governance, including protection of whistleblowers, decentralization process, and fusion of authority with accountability at all levels. This law provides us a precious opportunity to redesign the process of governance, particularly at the grassroots level where citizen interface is maximum. CIC Central Information Commission, Chief Information Commissioner, any Information Commissioner not more than 10, promotes transparency in public life, 5-year term of 65 years, removal by President order, misbehavior and incapacity. State Information Commission, Chief Information Commissioner, CIC, opposition leader, Cabinet Information Commissioner 1 to 10, information under Section 4, Clause 8, 5 years, 65-year removal by Governor. Key takeaway: achieve social justice, transparency, make accountable government, protect whistleblower, decentralization process, fusion of authority with accountability at all levels. Challenges: misuse the law and harass the public authority, asking for desperate and voluminous information to obtain publicity by filing RTI, illiteracy and unawareness, absence of grievance redressal mechanism. Conclusion was made to achieve social justice, transparency, and make accountable government, but this act has not achieved its full objective due to some impediments created due to systematic failure. RTI is necessary but not enough. A lot more is needed to be done to ensure accountability in governance, including protection of whistleblower, decentralization process, and fusion of authority with accountability at all levels. This law provides us a precious opportunity to redesign the process of governance, particularly at the grassroots level, where citizen interface is maximum. CIC Information Commissioner promote transparency in public life, 5-year term of 65-year removal by President order misbehavior and incapacity. State Information Commissioner, Chief Information Commissioner, 5 years 6 removal by Governor, achieve social justice, transparency, make accountable government, protect whistleblower, decentralization through the fusion of authority with accountability at all levels. RTI is a powerful tool for democracy. Use it wisely, make India accountable. SC or ST Prevention of Atrocities Act 1989. Background: for centuries, caste-based discrimination existed. Implant temporal status: earlier person's occupation, now hereditary. Post independence, Indian Constitution, fundamental right to equality, law to protect SC or ST, SC or ST, Prevention of Atrocities Act 1989, aim justice to SC or ST, obtain untouchability, Article 16, protection of Civil Right Act 1955 and IPC, form of atrocities, caste classes, caste discrimination, victimizing Dalits and Adivasis, honor killing, social boycott, harassment, public humiliation, manual scavenging leading to caste system, constitutional provision Article 46 to promote the educational and economic interests of marginalized society. Article 338 and Article 338A aim social justice, social dignity, inclusive society. Grand measure reservation policy, SC/ST Act 1989, reservation policy SC/ST Act 1989, Thorat Committee 2007. Study caste discrimination recommendation not implemented. Important component for centuries. End caste discrimination, social justice, equal rights for all, protect dignity of SC or ST, strong laws plus implementation, inclusive society, justice, dignity, equality, or constitutional provisions. SC or ST, Prevention of Atrocities Act 1989. Background: for centuries, caste-based discrimination existed. Implant temporal status, earlier person occupation, now hereditary and unalterable. Post independence, Indian Constitution, fundamental right to equality, law to protect SC or ST, SC or ST, Prevention of Atrocity Act 1989, aim justice to SC or ST, obtain untouchability, Article 17, Protection of Civil Right Act 1955, IPC. SC or ST, Prevention of Atrocities Act 1904, centuries. Caste-based discrimination existed. Post-independence, Indian Constitution, fundamental right to equality, law to protect SC and ST, obtain untouchability, protection of Civil Right Act 1955, IPC, SC or ST, Prevention Act 1989, aim justice to SC or ST, forms of atrocities, caste classes, caste discrimination, victimizing Dalits and Adivasis, honor killing, social boycott, harassment, public humiliation, manual scavenging linked to caste system, constitutional provision, Article 46 to promote the educational and economic interests. Article 46 to promote the Article 46 to promote the educational and economic interests of marginalized society, social justice, inclusive society, social dignity, grand measure reservation policy, study caste discrimination, SC/ST Act 1989, recommended Thorat Committee 2007. Key takeaway: end caste discrimination, social justice, equal right for all, protect dignity of SC and ST, strong laws plus implementation, inclusive society, justice, dignity, equality are constitutional promise. SC/ST SC/ST Prevention of Atrocities Act 1989. For centuries, caste-based discrimination existed. Post-independence, Indian Constitution, fundamental right to equality, law to protect SC/ST, SC/ST Act 1989, aim justice to SC/ST, obtain untouchability, Article 17, Protection of Civil Right Act 1955, IPC, Forms of atrocities: caste clashes, caste discrimination, victimizing Dalit, honor killing, social boycott, harassment, public criminalization, manual scavenging linked to caste system, constitutional provision, Article 56 to promote the educational and economic interests of marginalized society, Article 338 National Commission for SC, Article 338 National Commission for ST. Aim: social justice, inclusive society, social dignity, Grand Measure Reservation Policy, SC/ST Prevention Act 1998, Thorat Committee 2007. Features of SC and ST Act 1989. Section 3: Creation of new types of offence that are neither in IPC or in Protection of Civil Rights Act 1955. Punish crimes against people belonging to. Provide special protection and rights to victim witness information informer. Section 4: Create special courts and by particular special public prosecutor. Special court and special public prosecutor for speedy trials, completion of cases, commission of offences only by a particular person by non-SCs or non-STs on SC/ST, denial of anticipatory bail, mandatory and periodic monitoring system at the district, state and national level, identification of atrocity prone zone. Ministry of Social Justice is the nodal ministry. Prevention of Atrocities Act Amendment 2015. Some important provision or features are: new offences of atrocities are added, ensuring of head nourishment, garlanding with chappals, denying access to irrigation facilities, forest dispose of carcass or animal or human animal carcass using or omitting abusive, derogatory, etc. included in Act name. Committing atrocities, social or economic boycott, preventing from contesting election, touching or using words, creation of exclusive special courts of public prosecutor, power of special court to take direct cognizance, clearly define the term willful negligence. Define the term willful negligence of public servants at all levels. Justice, dignity, equality are commitment to protect SC or ST. SC and ST protection. SC and ST Prevention of Atrocities Act, Protection of Civil Rights Act 1925. Features of SC and ST Act. Section 3: Creation of new type of offences that are neither in IPC nor in Protection of Civil Rights Act 1955. Punishes crimes against people belonging to SC and ST. Provides special protection and right to victims, witnesses, informers and complainants. Creates special courts and a particular special public prosecutor. Commission of offences only by a particular person by non-SC, denial of anticipatory bail, mandatory and periodic monitoring system, at district, state and national, identification of atrocity prone zone. Ministry of Social Justice and nodal ministry. Prevention of Atrocities Act 2015. This and then provision and features are: new offences of atrocities are added, denying or cancelling human or animal carcass using insulting in caste name, weathering. Creation of exclusive special court and public prosecutor, power of special court to take direct cognizance, clearly define the term willful negligence of public servants at all levels. Offences under Act Section 3 and 14. Creation of new type of unpunished crimes. Important component. Fundamental right, Article 14 to 18. Religious, social and economic equality. Article 17. Abolish untouchability. Protection of Civil Rights Act 1955. Laws to protect SC/ST 1989. Aim: justice, equality and dignity. This act ensures social justice, equality, and dignity for SCs and ST. It provides strong legal protection, speedy justice and monitoring, special courts, special prosecutors, strict provision make it effective. SC and ST Act impact and advantages of PO Act: increase awareness, ensure reduction in crime rates, empowering right, awareness about right, ensure right to equality, protect unique identity and traditional practices, empowerment, political participation of Dalits, better education and health facilities, economically inclusive development, change in mindset, positive mindset. See also ensured right to equality, protected unique identity and traditional practices, political participation of Dalits, better education and health facilities, economically inclusive development. Low conviction rate, low conviction rate, less number of rehabilitated victims, unawareness regarding legal remedies and provision. Very few states have implemented preventive measure. One of the most misused law. Facts are 65% of hate crime against Dalits, with UP receiving the highest number of repeated crimes. There was 146%. The POA Act has increased awareness, ensured some reduction in crime rate, empowered right, ensured quality and protect in unique identity of SC and ST, encouraged political participation, better education, health, economic and inclusive development. But drawback like low conviction rate, lack of awareness, poor implementation, misuse of law remain challenges. Need stronger implementation, awareness and monitoring for real social justice, equality, and awareness plus rights plus justice is awareness plus rights plus justice equal to empowered society. SCST Act Prevention of Impact and Fine Back advantages: increase awareness, ensure reduction in crime rate, empowering rights, awareness about right, ensured right to equality, protected unique identity and traditional practices, empowerment, political participation of Dalit, better education and health facilities, economically inclusive, change in mindset, positive mindset, ensured right to equality, protected unique identity and traditional practices, political participation of Dalit, better education and health facilities, economically inclusive development. Drawbacks: low conviction rate, less number rehabilitated victims, unawareness regarding legal remedies and provision. Very few states have implemented preventive measure. One of the most misused law. 65% of hate crimes against Dalits, with UP receiving highest number of reported crimes. The PO Act has increased awareness and ensured some reduction in crime rate, empowered right, ensured equality and protected unique identity of and encouraged political participation, better education, health, economic inclusive. But drawbacks like low conviction rate, lack of poor implementation, misuse of law remain challenge. Need stronger implementation, awareness and monitoring for real social justice, awareness, right, justice, empowered society. CNST prevention of atrocity are duties and right. Duties of public servant: to read out an information of the informant and reduce to writing by the officer in charge of, to register a complaint of FIR under this act, to furnish a copy of the information, so to record the statement of the victim, to conduct the investigation, to correctly prepare, frame and translate any document or electronic record, to perform any other duty specified in this act, to register a complaint or FIR under this act, to recover the statement of the victim or witness, to perform any other duty specified in this act. Rights of victim and witness. Duty of state: make arrangement for protection of victim. Victim shall be treated with fairness, respect, and dignity. Right to reasonably accurate and timely notice of any court. For right to apply to the special court or exclusive special court to summon. Right to summon. Right to be heard. Right to summon. Right to be heard. Right to protection and justice. Traveling and maintaining expenses during investigation. Socio-economic rehabilitation or proceedings shall be video recorded. Duty of public servant: to read out an information of the informant and reduce to writing by the officer in charge, to register a complaint or FIR under the, to furnish a copy of the information so recorded, to record the statement, to conduct the investigation, file charges, to correctly prepare, frame, and translate any document, to perform any other duty, to register a complaint or FIR, to recover the state, to perform any other duty. Rights of victim and witnesses: protection, social rehabilitation, video recording, fairness and dignity, timely notice, right to summon, right to apply to the special court, exclusive special court to summon parties, right to summon, right to be heard, protection and justice. Duties of state: to provide copy of the FIR, to provide immediate relief in cash. Duty to provide copy of FIR, to provide immediate relief in cash, to provide necessary protection, to provide relief in case of death, to arrange food, water, clothing, shelter, transport, to provide maintenance expenses, to take necessary precaution during medical examination. Measure by state for effective economic and social rehabilitation, setting up committees, identification atrocity for legal aid to person, appointment of officer for supervision, periodic survey of working of provision. Duty of state to provide copy of the FIR free of cost, to provide immediate relief in cash, to provide necessary protection, to provide relief in case of death, to arrange food, water, clothing, shelter, medical aid, to provide maintenance expenses, to take necessary precaution during medical examination. Measure by state for effective implementation, economic and social rehabilitation of victims, setting up committees, identification of atrocity prone areas, legal aid to person, appointment of officer for supervision, periodic survey of working of provision, strong implementation, social justice, empowering SC and ST, building inclusive India. SC and ST prevention atrocities are duties of state. Measure for duty of state to provide copy of the FIR free of cost, to provide immediate relief in cash, to provide necessary protection, to provide relief in case of death, to arrange food, water, clothing, shelter, medical aid, transport facility, to provide maintenance expenses, to take necessary precaution during medical examination. Measures by state for effective implementation, economic and social rehabilitation of victims, setting up committees, identification of atrocity prone area, a legal aid to persons subject to atrocities, appointment of officer for supervision, periodic survey of working of provision. Protection of Women from Domestic Violence Act 2005. Protection Act 2005 against domestic violence. Definition of domestic violence. Section 3 includes physical abuse, sexual abuse, verbal, emotional, economic abuse, threats or any other conduct that harms or endangers the woman. Obligation to meet any lawful demand for dowry or other property is also an act of domestic violence. Features primarily meant for wives or females live-in partner. Secure housing is women's right. Law also extends to sister, widows, mother, girls as women right to secure housing. Court can issue protection order. Court can issue protection order. Appointment of protection officer. Breach of order is a non-bailable. Breach of order is a non-bailable offence. Application to magistrate section 12. An aggrieved person or a protection officer or any other person on her behalf. Aggrieved person or protection officer or any other person on her behalf can file an application. Magistrate on receiving application shall fix date of first hearing not beyond 3 days. First hearing within 3 days. First hearing within 3 days. Disposal within 60 days. Disposal of every application within period of 60 days. Monetary relief section 20. Monetary section 20. Loss of earnings, medical expenses, loss caused due to destruction, damage of any property, maintenance for aggrieved or children. Increase protection of women from domestic violence act 2005. Protection against 2005 Protection Act 2005 against domestic violence. Definition of domestic violence section 3 includes physical abuse, sexual abuse, verbal, emotional, economic abuse, threats or any other conduct that harms or endangers the woman. Obligation to meet any lawful demand for dowry or other property is also an act of domestic violence. Features primarily meant for wives of female live-in partner. Law also extends to sisters, widows, girls as women's right to securing housing. Court can issue protection order. Appointment of protection officer. Breach of order is a non-bailable offence. Application to magistrate section 12. An aggrieved person or protection officer or any other person on her behalf can file an application. Magistrate on receiving application shall fix date of first hearing, that is under 3 days, not beyond 3 days. Disposal of every application within period of 60 days. Monetary relief section 20. Loss of earning, medical expenses, loss caused due to destruction, damage of any property, maintenance for aggrieved or children. Protection Act 2005. Protection of Domestic Violence Act 2005. Protection against domestic violence. Definition of domestic violence section 3 includes physical abuse, sexual abuse, verbal, emotional abuse, threats or any other conduct that harms or endangers the woman. Obligation to meet any lawful demand for dowry or other property is also feature primarily meant for wives or female living partner. Law also extend to sister, widows, mother, girls as women right to secure as a court can issue protection order. A protection officer is appointed. Breach of order is a non-bailable offence. Application to magistrate section 12. An aggrieved person or a protection offer or any other person on behalf of him or her can file an application. A magistrate not beyond the 3 days, that is within 3 days, he has to fix the date of first hearing, disposal of every application within period of 60 days. Monetary relief section 20. Loss of hearing, medical expenses, maintenance for aggrieved or children, loss caused due to destruction, damage of any property, loss of earnings. Protection of Women from Domestic Violence Act 2005 against domestic Definition of domestic violence section 3 includes sexual abuse, physical abuse, verbal abuse, any threats that endangers the woman. Obligation to meet any lawful demand for dowry or other property is also an act of features primarily meant for wives of female living partner. Law also extends to sister, widows, mother, girls as women right to secure housing. Court can issue protection officer. Appointment of protection officer. Protection. Breach of order is a non-bailable offence. Application to magistrate, aggrieved person, or a protection officer, or any other person on her behalf can file an application. Magistrate, on receiving application, shall fix date of first hearing not beyond 3 days. Disposal of every application within a period of 60 days. Monetary relief, loss of earnings, medical expenses, loss caused due to destruction, damage of any property, maintenance for aggrieved or her children. Domestic Violence Act 2005. Protection Act 2005 against domestic violence. Definition of domestic violence. Section 3 includes physical abuse, sexual abuse, verbal, emotional, economic abuse, threats, or any other conduct that harms or endangers the woman. Obligation to meet any lawful demand or dowry or other property is also an act of domestic violence. Feature primarily meant for wives or living, but it also extend to sister, widows, mother, girls. Court can issue protection order. Appointment of protection officer. Breach of order is non-bailable offence. Application to magistrate. Section 2. An aggrieved person or protection officer or any other person or on her behalf can file an application. Magistrate, on receiving application, shall fix date of first hearing not beyond 3 days. Disposal of every application within period of 60 days. Monetary relief. Section 20. Loss of earning, medical expenses, loss caused due to destruction, damage of any property, maintenance for aggrieved or her children. Introduction. During early 19th century, many social legislation. During early 19th century, many social evils were prevalent. Sati Pratha was one of them. Many reform and awareness programs were launched, but practices couldn't be stopped even after being aware of its ill consequences. The efforts of Raja Ram Mohan Roy, who was successful in pursuing the British rule for implementing Sati Prohibition Act of 1829. It is after this only the old age practice of sati was removed from the society through social legislation. In modern societies, legislative action tend to be most important instrument in achieving social change. Those laws which are enacted for the purpose of social welfare are categorized as social legislation. Social legislation, social change in custom, belief, values, and norms, change in reform, efforts to remove social reforms, social legislation, laws made to bring social reform and change, social development, process of improving quality of life and overall progress. Features of social development primarily meant for during the Protection of Women from Domestic Violence Act 2005. During early 19th century, many social evils were prevalent. Sati Pratha was one of them. Many reform and awareness programs were launched, but practices couldn't be stopped even after being aware of its consequences. Efforts of Raja Ram were successful in pursuing the British rule for implementing Sati Prohibition Act of 1829. It is after this only the old age practice of sati was removed from the society through social legislation. In modern societies, legislative actions tend to be most important in achieving social change. Those laws which are enacted for the purpose of social, those laws which are enacted for the purpose of social welfare are categorized as social legislation. Social legislation includes social change, social reform, social development, social legislation, social change in custom, belief, values, and non-social efforts to social events, social legislation, laws meant to bring social reform, pushing social development process into the quality of life and all of progress. During the early 19th, many social evils that represent city preservers were found. One of them, many reforms of business program were learned the practices couldn't be so easy after the American consequences. Efforts of other among were successful pursuant to the British rule for implementing Sati Prohibition Act of 1829. It is after this only the old age practice of Sati was removed from the society through social legislation. In modern societies, legislative action came to be the most important instrument in achieving social change. Those laws which are enacted for the purpose of social welfare are categorized as social legislation. Social change in custom, belief, values, and social approach to social bring improvement. Social legislation laws make to bring social approach to quality of life and overall development. During early 19th, many social evils like many reforms in business did not fail launched, but practices couldn't be stopped even after the efforts of other however successful in prosecuting the practices Sati Prohibition Act of 1920 is after this only the old age practice of Sati was removed from the society. Social in modern society, legislative action tend to be the in modern legislative action tend to be the most important instrument in achieving social change. These laws which are enacted for the purpose of social welfare, category social legislation, social change, changing custom beliefs. Social change in custom belief, values, and social efforts to remove social laws meant to bring social reform and change social processes in the quality of life. Moral focus. Conclusion. Our constitution promises equality of all. To translate this promise into reality, social legislation are required. They give us the proper formalized legal framework for achieving our promises of equality and justice, but it has to be remembered by holistic approach that social change from holistic approach is more sustainable and acceptable to all sections of society. India in need of social legislation. India in need of social legislation pertaining to protect the domestic workers. Our constitution promises our constitution promises equality to all. To translate this promise into reality, social legislation are required. They give us the proper formalized legal framework for achieving our promises of equality and justice. But it has to be remembered by holistic approach that social support or holistic approach is more sustainable and acceptable to all sections of society. India in need of social legislation pertaining to protect the domestic workers. Our constitution promotes equality to all. To translate this promise into reality, social legislation are required to give us the proper formalized legal framework for achieving our promises for equality, accessibility has to be relevant, holistic approach. The social change brought by holistic approach is more sustainable and acceptable to all sections of society. This is like 1897 force method to tackle bubonic plague. Epidemic Disease Act 1897 first enacted to tackle bubonic plague in England. This law was made to contain by providing special legal provision section 2 when at any time state is satisfied of any dangerous epidemic disease and thinks that ordinary provision is sufficient, then it can empower any person or prescribe regulation to be observed by public or any person. Section 2 clause A for entire section 3 penalty punishable offence under section 188 of IPC ordinance 2000 up to 7 years of jail for Epidemic Disease Act 1897 first enacted to tackle Epidemic Disease Act 1897 first enacted to tackle bubonic plague. Epidemic Disease Act 1897 first enacted to tackle bubonic plague in Israel. This law was meant to containment. This law was meant to containment by providing special for legal provision section 2 when at any time state is satisfied of any dangerous epidemic disease and thinks that ordinary provision are insufficient, then it can empower any person or prescribe regulation to be observed by the public. Then it can empower any person or prescribe regulation to be observed by public. Section 2 Clause A for under Section 3 penalty punishable offence under Section 188 of IPC Ordinance 2000 receiving up to 7 years of jail for attacking doctors or health authority including as well as the cognizable and non-bailable time-bound investigation resolution under 1 year. Guilty has to pay twice the market value of damaged property as compensation. Epidemic Disease Act 1897 special powers to control dangerous epidemic disease section 2 when ordinary provision insufficient. State can empower or prescribe regulation for any person. State laws to protect doctor and health workers from a non-billable 7 years pay twice compensation. Epidemic Disease Act 1897 first enacted to tackle bubonic plague in Mumbai. This law was meant to contain but providing fresh cover. Legal provision section 2. When at any time state is satisfied of any dangerous epidemic disease or thinks that ordinary provisions are insufficient, then it can empower any person or prescribe regulation to be observed by public or any person. Section 2 clause A for entire Section 3 penalty punishable offence under Section 188 of IPC Ordinance 2000 up to 7 years of jail for attacking doctor and health including also cognizable and non-bailable time-bound investigation and resolution under 1 year. Guilty has to pay twice the market value of damaged property as compensation. Quick summary: Epidemic Disease Act special powers to control dangerous epidemic disease. Section 2 when ordinary provision insufficient, then it can empower any person. Then it can empower any person. Then it can empower any person. Then it can empower any person of the type regulation to be observed by public or any person. Ordinance 2000 strict laws to protect doctor or health worker cognizable non-bailable 7 years jail and twice compensation. Food Security Act 2013 passed by Food Security Act 2000 passed by Legislative Assembly. Food Security Act 2012 passed by Legislative Assembly on 22nd December 2012. First state in the country to implement the food security law. Families excluded who pay income tax or property tax on 4 hectares, who pay income tax on property tax on 4 hectares of dedicated or on 4 hectares of dedicated and 8 hectares of non-dedicated land in non-scheduled areas. Everyone who doesn't fall in above category is covered under food security bill. 4 hectares irrigated and 8 hectares non-irrigated. Comparison of provision types of ration fund. Confusion. Key point: food security for all. Protect the right. Food security for all. Protect the right to food. Ensure access to affordable food grains. Excludes high income or large landowner. Objective: to ensure food and nutrition security. Ensure food and nutrition security in life cycle approach. Food security is right to food plus access. Food security is right to food plus access. Food security is equal to right to food plus access plus affordability plus dignity. Food security passed by Legislative Assembly on 22nd December 2012. First state in the country to implement the Food Security Act. First state in the country to implement the food security law. Families included, families excluded, who pay income tax of property tax on 4 hectares of irrigated or 8 hectares of non-irrigated and non-scheduled areas. Everyone who doesn't fall in above categories covered under food security bill. Food security for all. Food security is equal to access plus affordability plus right to food plus dignity. ensure food and nutrition security in life cycle approach. Food security for all. Protect the right to food. Ensure access to affordable food. Ensure access to affordable food means food security, nutritional support. Food security, nutritional support, social justice, better quality of life. Food security, nutritional support. Food security, nutritional support, social justice, better quality of life. Food security, nutritional support, better quality of life, and social justice. Food security, nutritional support. Food security, nutritional support, social justice, better quality of life. Food security, nutritional support, better quality of life. Passed the Legislative Assembly on 22nd December 2012. First state in the country to implement the food security law. Families included pay income taxes operated on 4 hectares of irrigated or 8 hectares of non-irrigated land in non-scheduled areas. Everyone who doesn't fall in above categories toward the food security bill. Key point: food security for all. Key point: food security for all. Food security is right to food plus access plus affordability plus dignity. Protect the right to food, ensure access to all food grain affordable food, excludes high income or large landowners. Food security, nutritional support. Food security, nutrition support, social justice. Food security, nutrition support, social justice. Food security, nutrition support, social justice, quality of life. Food security is also right to food plus access plus affordability plus dignity. Cost to state treasury nearly 61% of in tribal areas. So cost to state treasury nearly 61% of stock in tribal areas. Salt and gram also distributed and offered to villages, agricultural elderly women not less than 18 years, head of the household for the purpose of issue of ration card in order to remain more than adult male member head. The role of local bodies, section 18, identification of eligible household, issuing ration cards, monitoring and supervision of fair price of identification of eligible household, issuing ration cards, monitoring and supervision of fair price shop, conducting social audit of the fair price shop, identification of providing relief to destitute or homeless person, grievance redressal mechanism. The state government shall put in place an integral grievance redressal mechanism. This may include call center, helplines, resignation of nodal officer, key taker, cost to state treasury nearly 61% of stock and tribal areas salt and dam also distributed to kg of jaggery. Women empowerment and elderly women as head of household is no other female than adult male member as head. Role of local bodies, identification of eligible household, issuing ration card to eligible household, monitoring and supervision of free fair price, social audit of fair price shop, identification of and providing relief to destitute and homeless person. Ensuring food security, empowering women and strengthening local body towards a fair and just. Cost to state treasury nearly 61% of stock in tribal areas, salt and gram also distributed in buffer 2 kg of jaggery and only women not less than 18 years head of household for the purpose of issuing ration card. If no adult female member, then adult male member. Identification of eligible household, issuing ration card, monitoring supervision of fair price shop, conducting social audit of fair price shop, identification of and providing relief to destitute or homeless person. Grievance redressal mechanism. State government should in place the internal grievance redressal mechanism which may include calls of the helpline, designation and order of the key taker cost to state treasury nearly 61% of tribal area. Salt and lemon also distributed in buffer 2 kg of jaggery, women empowerment, elderly women ahead of no adult female, then the main member, role of local bodies, identification of eligible household, issuing ration of free fair price shop, conducting social audit of the fair price shop, identification of and providing relief to destitute or homeless person, ensuring food security, empowering women, and strengthen local bodies towards a fair and just society. Other feature covers the PDS, school meals, Vlogmariz including take-home rations, not just food grain but also gram, iodine, salt, additional nutritional standards and calorie and protein value food given to children and pregnant and lactating mother, prevention against leakage and corruption, computerization of records and publication. Gram Panchayat will be allowed to run ration outlet. Officials will be punished for non-compliance with vigilance committee social audit for gram servers. Acts. Section 3 right to receive food at subsidized price. Section 4 nutritional support to pregnant plus lactating mother. Section 5 nutritional support to children. Section 6 nutritional support to student. Section 8 and 9 nutritional support to emergency or disaster affected person. Section 17 women of 18 years to pay their about to be right on household. Section 18 role of local bodies. Target beneficiaries pregnant and lactating mother, nutrition support children, nutrition support student, nutrition support Emergency or disaster affected person, nutrition of more than 18 years or above, head of household, role of local body, section 18, identification eligible. Other feature cover the PDS food used in our bodies, including take-home ration, not just food grains, but not just food grains, but also gram iodized salt. Additional nutritional standard like calorie and protein value food given to children, midday meals, and pregnant and lactating mother. Prevention against leakage or corruption. Compilation of records and communication upon beneficiary grant franchise will be allowed to environment affect. Official will be punished for non-compliant vigilance committee, social alternative grants of the Section 3 right to receive food at subsidized price. Section 4 nutritional support to pregnant plus lactating mothers. Section 5 nutritional support to pregnant nutritional support to emergency or disaster affected person. Section 17 women of 18 years of age are allowed to be head of household. Section 18 role of local bodies. Pregnant and lactating mother nutritional support children 0 to 6 years nutritional support student nutritional support emergency or disaster affected person nutritional support women 18 years or above head of household. Role of local bodies section 18 identification of eligible under issued ration card eligible of monitoring supervision of air pressure conduct of vehicle identification of and providing relief to distribute of 100% role of local body food safety air insurance right to food better nutrition transparency scheduled tribe and other traditional forest dweller rules to represent features the right to collect and sell minor forest produce, right to occupy the forest area which have been traditionally used for livelihood through occupation or agriculture for forest, portion belonging to scheduled tribe claim right to live and cultivate up to 4 hectares, right to live and cultivate up to 4 hectares, non-scheduled tribe living in the vicinity for at least 75 years prior to December 13. This could right to protect, regenerate, conserve, or manage any community forest resource. Definition community forest resource customary common forest land within the traditional and customary boundaries of the village. Forest dwelling scheduled tribe the members of community entities who primarily reside in and depend on the forest and protected areas. Minor forest produce all non-timber forest produce of plant origin including bamboo, brushwood, stones, canes, cocoons, honey wax, rainbow leaves, medicinal plants, fruits. Other scheduled tribe and other traditional forest dwellers. Scheduled tribe and other traditional forest dwellers rule 2007 features right to collect and sell minor forest produce, right to collect and sell minor forest produce, right to occupy the forest area which have been traditionally used for livelihood through occupation or agriculture work of forest. Person belonging to scheduled tribe claim right to live. Person belonging to scheduled tribe claim right to live and cultivate up to 4 hectares for non-scheduled tribe living in the vicinity for at least 75 years prior to 13 December 2005. Right to protect, regenerate, conserve, or manage any community forest resource. Right to protect, regenerate, conserve, or right to protect, regenerate, conserve, or manage any community forest resource. Definition community forest resource customary common forest land within the traditional or customary boundaries of the village. Forest forest dwelling schedule tribe. The members or communities of forest dwelling schedule tribe. Members or communities of estates who primarily reside in and depend on the forest tribe. Forest dwelling schedule tribe. Minor forest produce. Minor forest produce all non-timber forest produce of plant origin including bamboo, brushwood, honey bags, lac, casual leaves, medicinal plants, fruits, rose, timbers. Scheduled tribe and other traditional forest dweller rule 2007 teaches right to collect, sell minor forest produce, right to acquire the forest, right to occupy the forest area which has been used traditionally for the agricultural purpose, for livelihood, through occupation. Person belonging to scheduled tribe claim right to live and cultivate up to 4 hectares. For non-scheduled tribe living in the vicinity for at least 75 years prior to 13th December 2005, right to protect, regenerate, conserve or manage any community forest resource. Definition: community forest resource, customary common forest land within the traditional or customary boundaries of the village. Forest dwelling scheduled tribe. The members of communities of estates who primarily reside in and depend on the forest and protected areas. Minor forest produce all non-timber forest produce for plant origin including bamboo, honey wax, lac, tangerine, medicinal plants, rose, tubers and like. Teaches right to collect and sell minor forest produce, right to occupy the forest area which has been traditionally used for livelihood. Right to live and cultivate up to 4 hectares for non-scheduled tribe living in the vicinity for at least 75 years prior to 13th December 2005. Right to protect, regenerate, conserve, manage any community forest resource. Community forest is a customary common forest land within the traditional or customary boundaries of the forest dwelling scheduled tribe. The members of community of estates who primarily reside in and depend on the forest and protected areas. All non-timber forest produce of plants including bamboo, honey wax, lac, tangerine, medicinal plants. Rights of forest dwellers, recognition of forest right. Section: right to hold and live in forest land, right of ownership, access to collect, use and dispose of minor forest produce, rights in or over this protected land, rights of settlement, right to protect it, right generate, distribute, conserve or manage any community forest resource, right of access to biodiversity and community right to intellectual property. Any other traditional right customary enjoyed by forest dwelling tribe. Meaning of key terms: settlement, right to live in and cultivate, right to live and cultivate forest and protected, regenerate, conserve or manage any community forest as a right to protect, regenerate, conserve or manage community forest as a biodiversity and community right to intellectual property right. Any other traditional right, other right customarily enjoyed by forest dwelling tribe. Duties of forest dweller: protect the wildlife, forest and biodiversity, ensure that remaining catchment area, water sources and other ecological sensitive areas are adequately protected, ensure that habitat is preserved from any other kind of destructive activity or practices. Amendment 2012 Quorum of committee increased from 1/3 to 2/3. Permission can be given for local vehicles. Permission can be given for local vehicles for transport or small forest produce for livelihood. Runs are also limited, although the committee constituted for preparing conservation and management plan. Forest Right Act 2006 recognizes the right of forest dwellers right of forest dwelling by ensuring conservation, sustainable by ensuring conservation, sustainable use, and community participation. Rights of forest dwellers. Section 3. Right to hold and live in forest land. Right of ownership. Access to collect, use and dispose of my rights in or over disputed land. Rights of settlement. Right to protect, regenerate, conserve or manage any community forest resource. Right of access to biodiversity and community. Right to intellectual property. Any other traditional right customarily enjoyed by forest dwelling tribe. Meaning of key terms: settlement, right to live in and cultivate forest land, protected, regenerate, conserve, manage, municipality, biodiversity, protect the wildlife, forest, and biodiversity, ensure that adjoining catchment areas and other geographical, ecological, sensitive areas, educate, ensure that habitat is preserved for destructive activities. Rights of forest dweller, right to hold and live in forest land, hold and live in forest land, rights of ownership, access to collect and dispose of my rights in or over disputed, the right of settlement, right to protect it, regenerate, conserve or manage, right of access to biodiversity, settlement, right to live in and cultivate for protect, regenerate, conserve or manage, biodiversity and community, right to protect the wildlife forest, and biodiversity, ensure that ensuring catchment areas, water source are ecological sensitive areas, educate, protected habitat is preserved from any kind of destructive activity. Forum of permitting increase from 1 to 2 of permission can be given to those who for transport of small forest this year. Gram Sabha shall monitor and control the community conservation procedures for conservation of the Chhattisgarh Lok Seva Guarantee Act. Chhattisgarh Lok Seva Guarantee Act 2011 applied in state 2011. Every person shall have the right to obtain Lok Seva in Chhattisgarh. Definition: Lok Seva means and includes citizen related. Lok Seva means and includes citizen related services notified in Section 3 Public Authority. Any authority or body or institution of self-governance established or constituted by any law made by the legislature of the state. Section 3 right to obtain Lok Seva in stipulated time. Every person shall have the right to obtain Lok Seva in stipulated time. Who fails to obtain Lok Seva in stipulated time is entitled to receive. Every person shall obtain the right to Lok Seva in a stipulated time. The person who is not able to obtain the Lok Seva in stipulated time will be given the entitled to receive cost in respect of this application. Means and includes citizen related services. ability to deliver Lok Seva in stipulated time, imposition, recovery, and payment approach. Every department shall designate a person. Every department shall designate a person responsible for delivering Lok Sabha. Every application of Lok Sabha shall be acknowledged by the person responsible for delivering the service of the department. Every person responsible for delivering Lok Sabha who fails to deliver such service within stipulated time shall be able to pay cost 250 per day during period of delay. A part of day delay is equal to liability cost equal to 250 per day. Important points: rights for every person obtaining Lok Sabha in stipulated time delay entitled to receive cost equal to 50 rupees per day. Key takeaway: time bound public service delivery. Accountability of public authorities, penalty and delay cost to citizens, ensure transparency, efficiency, and good governance benefits, empower citizen, reduces delay, promotes responsible government, improve trust in public, time-bound service, right of citizen, responsibility of government. So here I am studying because next month I'll be appearing for my state PSC mains. That is on 6th June. Chhattisgarh Lok Seva Guarantee Act was the right to obtain Lok Seva. Chhattisgarh Lok Seva Guarantee Act 2000 right to obtain Lok Seva. Chhattisgarh in state 2000 every person shall have the right to obtain Lok Seva in Chhattisgarh. Lok Seva means and includes citizen related services notified in section 3 public authority. Any authority or body or institution of self-governance established or constituted by any law made by the legislature of the state. Section 3 right to obtain Lok Seva in stipulated time. Every person shall have the right to obtain Lok Seva in stipulated time. Who fails to obtain Lok Seva in stipulated time entitled to receive cost in respect of this application. Liability to deliver Lok Seva in stipulated time, imposition, recovery and payment of cost. Every department shall designate a person responsible for delivering Lok Sabha. Every application of Lok Sabha shall be acknowledged by the person responsible for delivering the service or by the department. Every person responsible for delivering Lok Sabha who fails to deliver such services within a stipulated time liable to pay cost 250 per day during day or period of delay or part of day. Important point: section 3 enforce right for every person obtain Lok Sabha in stipulated time delay entitled to receive cost equal to 50 per day delay. Key takeaway: time bound public service delay, accountability of public authorities, penalty and delay cost to citizen, ensures transparency, efficiency and good governance, benefits, empower citizen, reduce delay, promotes responsible governance, improve trust in public service, time bound service, right of citizen, responsible right time bound service, rights of citizen, responsibility of government. Right to public services, section 5, 6 and 7. Section 5, appointment of competent officers. Every department shall notify one or more person not below the rank of person responsible for delivering Lok Sabha as a competent officer for the purpose of this Act. Section 6, liability for furnishing false information. No person shall submit false application, otherwise may be liable for criminal action under law. Section 7, right of appeal. Any person aggrieved by an order passed by the competent officer entitled to file an appeal before the appellate authority, period not exceeding 30 days. Appellate authority shall decide the appeal Appellate authority shall decide the appeal within a maximum 48 hours of the appellate authority final mechanism. Section summary: appointment of competent officer by each department, liability for furnishing false information, right of appeal filed within 30 days, decision within 50, 40, decision within 45 days, for a final and binding. Section 5, appointment of competent officers. Every department shall notify one person not below the rank of the person responsible for delivering Lok Sabha as a competent officer for the purpose of this Act. Section 17, Section 6, liability for furnishing false information. No person shall submit false application otherwise will be liable for criminal action under law. Section 7, right of appeal. Any person aggrieved by an order passed by the competent officer entitled to file an appeal before the appellate authority period not exceeding 30 days. Appellate authority shall decide the appeal within a maximum of 45 days. The order of the appellate authority final is final. Section 7, appointment of appellate officer by appointment of competent officer by each department, liability for filing possession falls under the right of the file within 30 days, within 45 days. Order final and binding. Officer upon duty for false information penalty appeal within 30, answer within 40 order final. Key takeaways: this section ensures accountability, transparency. Key takeaways: this section ensures accountability, transparency, and time-bound delivery of. This section ensures accountability, transparency, and time-bound delivery of public services within a clear appeal mechanism. Right to public services, section 5, 6, 7. Appointment of competent officers. Every department shall notify one or more person not below the rank of person responsible for delivering Lok Seva as a competent officer for the purpose. Section 6, liability for furnishing false information. No person shall submit false application. Others may be liable for criminal action under law. Section 7, right of appeal. Any person aggrieved by an order passed by the competent officer entitled to file an appeal for the appellate authority. Appellate authority shall decide the appeal within a maximum of 45 days. The order of appellate authority final and binding. Section 5, appointment of competent officer by each department. Section 6, liability for furnishing false information. Section 7, right of appeal filed within 30 days. Within 45 days, order final and binding. This section ensures accountability, transparency, and time-bound delivery of public services within a clear appeal mechanism. Chhattisgarh Tony Prath Practice 2005. Tony, a person indicated any person, a person that will, a person indicated by any person, person indicated by any person, or a person that will harm or possess power to harm, thereby is intended to harm. Black magic, EV life of any element, known as Diane Toner or by any other name, posing a person claims to possess power to control, cure, treat Tony or any other person or member living thing believed to be affected by Tony and make him powerless by Jhar Vodka stony. Whoever identifies any person as stony by any means shall be punished with rigorous imprisonment for a term which may extend to 3 years or also defined. Section 5 Punishment for force or harm. Whoever causes physical or mental harassment or damage to any person. Hi guys.